All right, it's Wednesday, January 29th, 2025. 4:02 p.m. My name is Kessie Ian Anderson, and welcome back for another edition of Heresiarch. In this edition, we are going to discuss the Association for Molecular Pathology versus Myriad Genetics, Inc., and why the Supreme Court launched a legal nuclear blast onto all of us.
Sophisticated surveillance regimes throughout the world, not just by authoritarian regimes, but also by democratic governments. The US, for example, is building a global surveillance system, while my home country of Israel is trying to build a total surveillance regime in the West Bank. But control of data might enable human elites to do something even more radical than just build digital dictatorships. By hacking organisms, elites may gain the power to re-engineer the future of life itself. Because once you can hack something, you can usually also engineer it. And if indeed we succeed in hacking and engineering life, this will be not just the greatest revolution in the history of humanity. This will be the greatest revolution in biology since the very beginning of life 4 billion years ago. For 4 billion years, nothing fundamental changed in the basic rules of the game of life. All of life, for 4 billion years, dinosaurs, amoebas, tomatoes, humans, all of life was subject to the laws of natural selection and to the laws of organic biochemistry. But this is now about to change.
I could argue in the developed countries, the big winners are countries that have shrinking populations. Okay, that's something that most people never talked about. You know, we always used to think shrinking population is a cause for negative growth. But in my conversations with the leadership of these large developed countries that have xenophobic immigration policies, they don't allow anybody to come in, shrinking unemployment, shrinking demographics, these countries will rapidly develop robotics and AI and technology. And if the promise, I didn't say it's going to happen, but if the promise of all that transforms productivity, which most of us think it will, we'll be able to elevate the standard of living of countries and the standard of living of individuals, even with shrinking populations. And so the paradigm of negative population growth is going to be changing. And the social problems that one will have in substituting humans for machines is going to be far easier in those countries that have declining populations. And so for those countries that have rising populations, the answer will be education, and so rapidly develop. You know, for those countries that do not have a foundation of rule of law or education, they're going to be left. That's where the divide's going to get more and more extreme. And unfortunately.
All right, so October, this case was argued April 15th of 2013, and it was decided June 13th of 2013. The Supreme Court of the United States. Association for Molecular Pathology et al. Versus Myriad Genetics, Inc. et al. Certiorari to the United States Court of Appeals for the Federal Circuit. Docket number 12-398. Each human gene is encoded as deoxyribonucleic acid, DNA, which takes the shape of a double helix. Each crossbar in that helix consists of two chemically joined nucleotides. Sequences of DNA nucleotides contain the information necessary to create strings of amino acids used to build proteins in the body. The nucleotides that code for amino acids are exons, and those that do not are introns. Scientists can extract DNA from cells to isolate specific segments for study. They can also synthetically create exons-only strands of nucleotides known as complementary DNA, cDNA. cDNA contains only the exons that occur in DNA, omitting the intervening introns. Respondent Myriad Genetics Inc., Myriad from here on out, obtained several patents after discovering the precise location and sequence of the BRCA1 and BRCA2 genes, mutations of which can dramatically increase the risk of breast and ovarian cancer. This knowledge allowed Myriad to determine the gene's typical nucleotide sequence, which in turn enabled it to develop medical tests useful for detecting mutations in these genes in a particular patient to assess the patient's cancer risk. If valid, Myriad's patents would give it the exclusive right to isolate an individual's BRCA1 and BRCA2 genes, and would give Myriad the exclusive right to synthetically create BRCA cDNA. Petitioners filed suit seeking a declaration that Myriad's patents are invalid under 35 U.S.C. 101. As relevant here, the district court granted summary judgment to petitioners, concluding that Myriad's claims were invalid because they covered products of nature. I'll stop right there. This is why all the holistic doctors push back on the Judeo-corporate medical establishment. So holistic doctors that push all of their stuff, you can't patent it because they do natural remedies. But that is where the money system goes with big medicine, big pharma, pharmakia, is because of the money. Once they get a patent on a drug, they're golden. They have money from here to forever once they get that patent. So, as relevant here, the district court granted summary judgment to petitioners, concluding that Myriad's claims were invalid because they covered products of nature. The Federal Circuit initially reversed, but on remand in light of Mayo Collaborative Services versus Prometheus Laboratories, Inc., 566 U.S., the circuit found both isolated DNA and cDNA patent eligible. So what does remand mean? Let's go here and see. In law, remand means to send a case or person back to a lower court or to custody, respectively, for further action. When an appellate court reverses a lower court's decision, it may remand the case back to the lower court for reconsideration. A higher court may remand a case if it finds errors in the lower court's decision. A court may remand a case to a federal agency for reconsideration of a regulation or administrative decision. So they remanded the case in light of Mayo Collaborative Services versus Prometheus Laboratories, Inc., 566 U.S., the circuit found both isolated DNA and cDNA patent eligible. So again, cDNA, complementary DNA. Now held, a naturally occurring DNA segment is a product of nature and not patent eligible, merely because it has been isolated. But cDNA is patent eligible because it is not naturally occurring. The Patent Act permits patents to be issued to whoever invents or discovers any new and useful composition of matter. But laws of nature, natural phenomena, and abstract ideas are basic tools of scientific and technological work that lie beyond the domain of patent protection, meo supra. The rule against patents on naturally occurring things has limits, however. Patent protection strikes a delicate balance between creating incentives that lead to creation, invention, and discovery, and impeding the flow of information that might permit, indeed spur, invention. This standard is used to determine whether Myriad's patents claim a new and useful composition of matter, 101, or claim naturally occurring phenomena. And that's a big point. How many of these big corporations have used their patents to destroy the little guy? Everybody knows. Everybody knows. In fact, anybody who invents something, chances are, if it has anything to do with a new engine, that will get purchased, lawsuited, or shelved, or the person just goes mysteriously missing. So, Myriad's DNA claims fall within the law of nature exception. Myriad's principal contribution was uncovering the precise location and genetic sequence of the BRCA1 and BRCA2 genes, Diamond versus Chakrabarty, 447 U.S. 303. is central to the patent eligibility inquiry whether such action was new, with markedly different characteristics from any found in nature. Myriad did not create or alter either the genetic information encoded in the BRCA1 and BRCA2 genes or the genetic structure of the DNA. It found an important and useful gene, but groundbreaking, innovative, or even brilliant discovery does not by itself satisfy the 101 inquiry. See Funk Brothers Seed Company versus Kahlo Inoculant Company, 333 U.S. 127. Finding the location of the BRCA1 and BRCA2 genes does not render the genes patent eligible. New compositions of matter. Myriad's patent descriptions highlight the problem with its claims. They detail the extensive process of discovery, but extensive effort alone is insufficient to satisfy 101's demands. Myriad's claims are not saved by the fact that isolating DNA from the human genome severs the chemical bonds that bind gene molecules together. The claims are the chemical changes resulting from the isolation of a particular DNA section. Instead, they focus on the genetic information encoded in the BRCA1 and BRCA2 genes. So let's go and find out what are the BRCA1 and 2 genes. BRCA1 and BRCA2 are genes that help repair DNA and prevent cancer. People with mutations in these genes have an increased risk of developing breast and ovarian. So basically, if Myriad would have won this, they would have had the market on breast cancer. We'd have been walking for cures forever. Which, I mean, in this industry, I don't have confidence, Project Stargate, that we're ever going to cure cancer. And if we do, are we? So BRCA1 and BRCA2 are tumor suppressor genes that help prevent cells from growing and dividing too quickly. And that is what cancer is, the abnormal division and uncontrollable division of cells in a part of the body. So they are part of the homologous recombination repair, HRR pathway, which repairs double-stranded DNA breaks. What happens when they mutate? Mutations in BRCA1 and BRCA2 prevent the genes from working properly, increasing the risk of cancer. People with these mutations tend to develop cancer at younger ages. So let's go back to this. Myriad argues that the Patent and Trademark Office's past practice, let me make sure I get this centered here. Myriad's claims are not saved by the fact that isolating DNA, human genome severs. Okay, the claims are not expressed in terms of chemical composition, nor do they rely on the chemical changes resulting from the isolation of a particular DNA section. Instead, they focus on the genetic information encoded in BRCA1 and BRCA2 genes. Finally, Myriad argues that the Patent and Trademark Office's past practice of awarding gene patents is entitled to deference. So that means they are arguing that because in the past they have given certain patents, they must defer to the precedent that was set by those rulings. There has been no such endorsement here in the United States, argued in the Federal Circuit and in this court, that isolated DNA was not patent eligible under 101. So, cDNA is not a product of nature, so it is patent eligible under 101. cDNA does not present the same obstacles to patentability as naturally occurring isolated DNA segments. Its creation results in an exons-only molecule, which is not naturally occurring. Its order of the exons may be dictated by nature, but the lab technician unquestionably creates something new when introns are removed from a DNA sequence to make cDNA. This case, it is important to note, does not involve method claims, patents on new applications of knowledge about the BRCA1 and BRCA2 genes, or the patentability of DNA in which the order of the naturally occurring nucleotides has been altered. Affirmed in part and reversed in part. So you have to understand about this case. What does this case do? So let's jump into Myriad really quick. Myriad Genetics. Patients, providers, biopharma are tests. Breast cancer, ovarian cancer, pancreatic cancer, prostate cancer, endometrial cancer, other cancers, all tests. Now, Economics 101, people respond to incentives. We have to play the fiat federal currency game, and we all have to make money to survive. And if you can get people coming back for your product again and again and again, what better thing to do? So Myriad Genetics, like a high-tech 23andMe, I suppose. So you can do DNA tests and get assessments: fetal sex, chromosome condition, genetic diseases, hereditary cancer, depression, etc. Now, why did the Association of Molecular Pathology file a lawsuit against Myriad Genetics? Here's the AI overview. The Association for Molecular Pathology, AMP, filed a lawsuit against Myriad Genetics because they challenged the company's patents on the BRCA1 and BRCA2 genes, arguing that genes are products of nature and therefore cannot be patented, effectively preventing other researchers and laboratories from developing genetic tests for these genes, which are crucial for detecting breast and ovarian cancer risk. So yeah, they would have owned the market. And limiting patient access to testing options due to Myriad's monopoly on the technology. This case ultimately went to the Supreme Court and set a precedent against patenting human genes. Let's look at the key points. Gene patents at issue. Myriad Genetics had patents on the BRCA1, BRCA2 genes, which are associated with an increased risk of breast and ovarian cancer. AMP argued that isolating a gene from the human genome does not constitute an invention, as it is simply discovering a naturally occurring biological process. The lawsuit claimed that Myriad's patents hindered research and limited access to genetic testing by preventing other labs from developing their own tests. In 2013, the Supreme Court ruled in favor of AMP, declaring that isolated human genes are not patentable because they are products of nature. So the district court found that DNA isolated by Myriad is not markedly different compared to DNA in its natural form, so it cannot be patented. The court also reviewed Myriad's claims on comparing and analyzing DNA sequences and found that those were not eligible for a patent. Now, if you keep going, they're not telling us this in these little Google hides. For the reasons that follow, we hold that a naturally occurring DNA segment is a product of nature, not patent eligible, merely because it has been isolated, but that cDNA is patent eligible because it is not naturally occurring. We therefore affirm in part and reverse in part the decision of the United States Court of Appeals for the Federal Circuit. Genes form the basis of hereditary traits in living organisms. The human genome consists of approximately 22,000 genes packed into 23 pairs of chromosomes. Each gene is encoded as DNA, which takes shape blah, 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 blah. Thymine, cytosine, and guanine, adenine, each which binds naturally with another nucleotide. A pairs with T, C pairs with G. The nucleotide crossbars are chemically connected to sugar phosphate backbone and forms a sequence framework of the DNA helix. Sequences of DNA nucleotides contain the information, yada, yada, yada. Creation of proteins from DNA involves two principal steps known as transcription and translation. In transcription, the bonds between DNA nucleotides separate and the DNA helix unwinds into two single strands. All right, let's keep going. Trying to find here. This synthetic DNA created in the laboratory from mRNA is known as complementary DNA. So let's back up. DNA's informational sequences and the processes that create mRNA amino acids and proteins occur naturally within cells. Scientists can, however, extract DNA from cells using well-known laboratory methods. These methods allow scientists to isolate specific segments of DNA. For instance, a particular gene or part of a gene which can be further studied, manipulated, or used. It is also possible to create DNA synthetically through processes similarly well-known in the field of genetics. One such method begins with an mRNA molecule and uses the natural bonding properties of nucleotides to create a new synthetic DNA molecule. The result is the inverse of the mRNA's inverse image of the original DNA, which with one important distinction. Because the natural creation of mRNA involves splicing that removes introns, the synthetic DNA created from mRNA also contains only the exon sequences. This synthetic DNA created in the laboratory from mRNA is known as complementary DNA, cDNA. That's patentable. So I'm just going to stop right there. This Supreme Court case blew open Helm's Deep. The Urukai carrying the bomb went running at the gate with his mRNA strand and cDNA and blew open the gate. So let's fast forward to 2020. Is the spike protein synthetic? Spike protein pathogenicity, termed spikiopathy, whether from the SARS-CoV-2 virus or produced by vaccine gene codes akin to synthetic. Synthetic SARS-CoV-2 spike-based DNA vaccine elicits robust and long-lasting Th1 humoral and cellular immunity in mice. The synthetic mRNAs, such as those expressing the SARS-CoV-2 spike protein, are equipped with analog caps that further inhibit physiological. All right. An AI overview is not available for this search, of course. So, here's where it is going to go. Now, I'm going to burst some people's bubbles. This might be news to some of you. But when a president can sign an executive order, he's on par with a king. It does not go through the checks and balances. So, for those of you in the fantasy world, the Constitution is nothing but a meme. It's a little security blankie that we hold and think something our wet nurse told us at night. It's a meme. It does not mean anything. So, newsflash to anybody who wasn't aware. The whole idea of an executive order, the whole idea of a president having the power of a king to just wave his pen and sign things into law, whether they benefit you or whether they benefit somebody else or whether you feel like you're owning somebody, how constitutional is that? I'm just saying the Constitution is a meme. It doesn't matter anymore. They will... Whatever you want to slippery slope, whatever these big pharma companies want to do with being able to patent synthetic DNA, CRISPR-Cas9, this all has laid the groundwork for the biodigital convergence. This has laid the groundwork for all of these people to have the monetary incentive to push this further at us. So we lose in all ways. Oh, it'll go to court. Yes, it will go to court. There will be little ironings out lawfare, but lawfare does nothing for us. We will always lose. This is a steamroller that will not be stopped. So they're going to keep steamrolling us. They're going to keep passing. They're going to keep creating. They're going to CRISPR-Cas9 us. They're going to use all of this stuff to keep hitting us over and over and get us on the subscription. So the big reveal we're going to find out at some point when we diverge as a species, one bit of humanity tries to go one direction and another bit of humanity goes the tech direction. You're going to find out real quick when they try to patent you because you are now no longer considered an organic, naturally occurring person. Sounds crazy, but it's already in place. I mean, what is that? Repo Man material. Go and don't pay your fee and lose your kidneys again because you didn't pay the subscription fee. Or they just turn off the AI precision healthcare. The electricity is not going to zap you in the cells that are supposed to. So with Project Stargate, this court case, Myriad Genetics, Association for Molecular Pathology versus Myriad Genetics Inc., everything is in place. So that's it. I'm going to stop there. Next video, I'm going to continue on the BioDigCon website and go into the second half that I did. And that was a belabored long video. So we'll cut this down a little bit. I'm trying to get the OBS system down to present a little better and get my green screen functioning better. So anyway, thank you for joining me and wasting your time with me. Until next time.